Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I also have some really important information that I need to talk to you about tonight. So, the USCIS has announced some major changes in the USCIS policy manual, and these changes have to do with family and marriage based petitions. So if for the green card, so if you're going for the green card, you want to know whether you qualify through a family member or through marriage, you're going to want to sit in for this because there are a number of changes or even just clarifying information from the policy manual that I have to tell you about. This is going to be important because it's going to tell you how to approach your case, and it's going to really help you to understand what's at stake. Now, we knew these changes were coming. It's now in writing and it has been published in the USCIS policy manual. I'm going to go over those. So for one of the one thing that we saw they talked about in regards to changes are the mandatory interviews. So we knew that that was happening. No, in the previous administration, they could have waived those interviews if the case was pretty straightforward, the documentation was was sufficient. They would waive it, and we started to see a lot of green card interviews being waived. However, that is going to change. And the reason that's going to change is because there's a lot more emphasis on screening for fraud, for different types of immigration violations. So you want to make sure that you understand how to be ready for that interview. When you're submitting your applications for family-based as well as marriage-based, doesn't matter if it's a parent sponsoring you and it's quite obvious that they're your parent, you need to make sure everything is correct and make sure that you're preparing this application in preparation for the interview. You start to prepare for the interview by submitting a thorough application. Believe it or not, and this is what I have in my practice, what I've realized, the better and more thorough the application is at the start, is the better the interview is going to be. The outcome of your interview is likely going to be a good outcome, and you're going to have a smoother process when you put a good application together. One of the pitfalls I've seen happen is many people just think they have to get the application in, especially with marriage-based cases. It's like, I just need to get this in. So, the marriage-based cases, in those cases, you get married and then you file that application very quickly after you get married. And then you're like, I don't want to, I can worry about the rest of the information I have to submit later on to show that the marriage is real. We are very successful in our marriage-based cases because we do not take the approach of rushing anything. Now, of course, we file it as soon as we can. But when I'm saying rushing, I mean that we're not going to sacrifice the quality of the application for speed. Unless, of course, we do come up with a plan. If there is a deadline coming up, we come up with a plan and a strategy to approach that, to file quickly, as well as to be able to supplement the evidence very quickly. However, we do not just file things, because we know that if we file an application that is lacking in evidence, it's going to create create more likely delays. It's going to create a situation where we're going to get requests for evidence, where we could have avoided that from the get-go. And I'll talk about that request for evidence because we may not be able to fall back on that anymore. You can't depend on that request for evidence, and I'll explain later what that means exactly. But and when we get to the interview, the officer will have everything they need to make a decision, and we're not surprised by any of the questions that they're asking because we have prepared thoroughly by preparing the application, but also for the interview. So very important, guys, that you make sure that you know by submitting a solid application, you're already giving yourself a head start for that interview, because interviews are now going to be mandatory in most cases, and that's because they're focusing on fraud detection. Now, there are some red flags that you need to make sure that you're aware of. Red flags they are looking out for. And in some cases, you may not be able to avoid being being red flagged, of course. But what it means, though, is that you have to be prepared to go in and make sure that you are prepared to answer questions. So here are some of the red flags that they are looking out for that you need to be prepared for. So one is if the spouse is under 18. Yes, guys, I know we all have different beliefs about the age at which somebody can get married. Believe it or not, though, in immigration, there is really no age limit when it comes to the marriage-based green card. So what they're saying, though, is that they're going to focus on whether there is some kind of fraud involved if the person, the one of the spouses, is under the age of 18. Or, and in this case, this doesn't have to do with anybody under 18, but if there is an age gap, right, a big age gap. So if there's an age gap of maybe 10 years, then you can expect that they're going to hone into that and they're going to start asking more questions. Now, of course, keep in mind with age limit, it doesn't mean when I say they're going to focus on people under 18, of course, that marriage with anybody who's under 18 is considered legal, either in the country or in the state. And believe it or not, you do have some states that with parental permission, somebody under 18 can get married. So that explains that, but they are going to start focusing on those types of marriages. Now, if there was a past I-130 petition that was denied, that was withdrawn, or that was revoked, they're going to, and so you had a past petition and now you're filing for another petition. Must know that you are going to be red flag. They're going to hone into that. They're going to reopen the old. There is the possibility of them reopening the old I-130 that was denied to make sure that there's no fraud. So they're going to be looking for consistency. They're going to be, or inconsistencies, to flag any kind of fraud or misrepresentation. So make sure that you're aware of that. And when submitting applications, for example, whenever there's a past application that was denied, we like to go backwards and do a FOIA to be able to see what's going on with the old application. So we are not surprised by anything that comes up and that we are able to properly advocate for our clients. So if you have a past denied, revoked, or withdrawn I-130, they're going to look at everything. And so you're going to be red flag. They're going to hone into that likely at the interview. If the immigrant beneficiary is in removal proceedings, you're going to have an interview. Now, why I'm saying this is the I-130s, the I-130 petition, guys, does not usually have interviews. So what they're talking about here is the I-130 petition. The interviews, marriage-based interviews that we know about, they usually goes along with the adjustment of status interview. But now they're saying if you say you just filed a standalone I-130 petition, you could be called in for an interview based on these red flags. So the other is, and I mentioned this before, if the application was submitted with very little evidence or weak evidence, missing information or inconsistencies, you can count on getting an interview. So this is where, once again, I caution you against rushing. I know a lot of people right now, you may be in relationships right now and you may be like, let's just get married and let's just file the paperwork. Know that this is not just paperwork. This is your future, but also know that it's not just you filling out a form. It's really gathering the right evidence to show that, to make a strong case. The focus here is going to be the strength of your case, not the speed of your case, right? Not the fact that you just filed it. It's the strength of your case. So make sure that you now, do you help people from Dominica? We help people from all over the world. Not, we help everybody. So give us a call if you need to have immigration, you have immigration case, you need representation on it, give us a call. That's what we're here to do. We're here to help everybody who needs it. All right. Now, you may be going into this saying, but I have a real marriage. This is a real marriage. So I don't have anything to worry about. And look, some of the things that I listed here are beyond your control, right? You may have a real marriage, but you have a 10-year age gap that they're going to target, they're going to focus on. So you have to make sure that you approach this application with strength rather than speed, and don't and no missing information, no missing evidence. There's no room for errors here. Now, there's no room for errors here, guys, because here's the other change that's coming. There is now going to be no second chances, right? Or the possibility they may give you second chances, but it's going to depend on the officer's discretion. Now, what was happening before is they would issue what's called a request for evidence or a notice of intent to deny. The both of them don't sound good. And, when I do see one of those, I, cringe. But on the positive side, what it really means is they're giving you a chance to be able to provide information that will get you an approval. So they're saying, listen, we're leaning to the side of denial. However, if you give us this information we're looking for, we can turn this into an approval. We can change our minds. That we're going to see less of those and more denials, because what they're saying is they can deny without warning and the way they would warn is through a request for evidence or a notice of intent to deny. So they're saying now they can just deny it. They don't have to ask you or give you a chance. So the stakes are a lot higher. So you cannot depend on submitting an application very quickly and then saying, oh, and they'll just issue a request for evidence and I can then just send them that information. You cannot depend on that happening. So missing any kind of missing documents or documents that aren't formatted right, missing translation, certified translations, missing medical records, missing proof of relationship like marriage certificates, proof of status like green cards or citizenships to show relationships will or can lead to a denial. Hi, good night. Are you in Boynton Beach? We're not in Boynton Beach, but we are in Delray Beach, right next to Boynton Beach. So, guys, make sure that there's no room for error, really. There's no room for error. This is how you have to treat it. Now, filing a family petition, and this was always the case, but they're emphasizing it here. So, filing a family petition does not mean protection from deportation. Now, I want you to understand that there's a difference between filing for a petition, a family petition, and filing for adjustment of status. A petition alone, like the I-130, so if your parents say you're here, you're over 21 and your US citizen mother decides to file for you, they're going to file an I-130 petition. Will that protect you from detention or deportation? No, it will not. Right? So just know that while an I-130 is pending, you may still be issued a notice to appear in immigration court and still be going through the deportation process at the same time. But what you do need to see is, do you qualify for adjustment of status? Because adjustment of status can give you temporary protection while your case is going through. And you do get a work permit and a travel document while you're applying for adjustment of status. Adjustment of status in some cases can go along with family petitions or marriage-based petitions. So you want to be able to check to see if you qualify for that and make sure you're filing for that as well. Now the other thing is and I don't think this is not a bad thing, actually. I mean, in some cases it is, but they're going to automatically, so if there's a major life change, there's a marriage, or let's leave the marriage. The marriage is going to have a different implication. Say your US citizen, your US permanent resident spouse became a US citizen. What they're going to do is now keep in mind, this is not a simulation. I think it's a simulation. No, it's not a simulation. What I'm doing is I'm giving you information updates. I'll definitely get to your questions afterwards, but it's so important for me to share these updates with you. So please be patient with me. Take in what I'm telling you, because this is essential information that you need to know about. This is changes that the USCIS has announced. So no, I'm not AI. This is not a repeat of the live. I'm giving you updated information, but I want to get through it and then answer your questions. So put your questions in the comments, and then I'll get to it as soon as I'm finished with everything that I'm talking about here, because I want to make sure you get this. So they're going to be doing, I don't think this is a bad thing. They're going to be doing automatic conversions of case types. If they're, for example, if your US permanent resident spouse turns to a US citizen and and your spouse filed an I-130 petition, now you're going to get an upgrade from category of spouse of permanent resident to immediate relative of a US citizen. So that means that your case is going to move faster because you're going to be in a different category. Now, realistically, do I expect them to do this automatic conversion quickly? No, I don't, with everything else. And usually if they're gonna do an automatic conversion, they have to get some kind of notification, and getting that notification and then getting to your file to make that automatic change, it's gonna take time. What I do suggest is you still notify USCIS of changes, major changes, like if your spouse goes from a permanent resident to a US citizen, notify them so that they can make the change faster. Don't just sit down and say, oh, they'll do it, because you can't necessarily depend on them to move very quickly. But there's a negative to this, right? And this has always been the case, guys. I wouldn't say this is a major change. The automatic conversion is a change that they said they're going to do. But what this also means, though, is that if a child ages out, they're going to automatically change them or downgrade them or completely cancel the application for lack of eligibility. So this is where it's very important to make sure that you're evaluating any changes that you're going to make, any major life changes, marriages. If there's a birthday coming up, somebody's about to turn 21. If there's a divorce coming up, you need to evaluate how that's going to affect your application. So you're prepared. You see if you can take some action or not take action to avoid any kind of changes that are going to affect you negatively in your application process. So this has to do with individuals who are seeking to file I-130s at the U.S. embassies outside of the United States. So this doesn't have to do with family petitions in the U.S., but they've narrowed the conditions under which U.S. citizens can apply for the I-130s at the embassies. They've restricted it only to military service members, U.S. government employees who are on mission abroad, emergency cases. So if there's a medical emergency, safety threats, then the I-130 could be filed at a U.S. embassy. And I believe it's U.S. citizens who are outside of the United States who are maybe looking to see if they can bypass the fast or get a faster processing time that do these. However, it's going to change. It's more narrow now, and it's restricted to only certain people. There is the normal process that you can file an I-130 online and go through the regular process. So that's just for people who are considering applying I-130s outside of the US. Now, if for anybody who has had multiple petitions filed for them, multiple petitions by the same person, keep in mind that that could have a negative impact on the application. It's going to red flag the immigrant applicant, and they're going to investigate for fraud. And in addition to that, they're not going to treat each case individually. If you filed an I-130 and then for some reason it was denied, and then you filed an I-130 again, they're going to treat that second I-130 filed as if it was a continuation of the first I-130. They're going to review everything, and then they're going to see whether there's some kind of fraud involved or eligibility issues involved. So be careful, because filing multiple can turn into a nightmare, and it can delay your case because now it's going to be red flagged. And in some cases it's unavoidable. You have to refile. We get it, right? But just know that it may cause delays because of the multiple filings. And they are going to reopen the old one, look at the old files to determine whether there's any kind of fraud involved. So it's always important, if you're going to go ahead and submit any applications that you may have filed previously, you need to make sure that you understand what you answered, what you put in the first applications, because they're going to be looking for inconsistencies. They're going to be looking at any kind of indications of omissions or misrepresentation in all the applications. They're not going to treat each application as individually. They're going to look at them as a whole, the multiple applications that were filed. Now, here's a big one. Withdrawing a petition is final. Yes, a petition, so say your U.S. citizen spouse filed a letter with USCIS to withdraw the petition. They changed their mind. They don't want to sponsor you anymore. That they're saying that withdrawal is final. No reopening of the case, no changing mind later on. You have to refile the case. And as we see, refiling the case has its own risk. in itself. Now, and here's the other thing is they can still take away the green card approval after a withdrawal. So if the U.S. citizen says, you know what, you say you got an approval notice as an immigrant, you got the approval notice, but you didn't get the green card yet. You got the notice, and then even then you're like, you know what, nah, I I don't want to go forward with this anymore. And so you go ahead and write and say you'd like to cancel the petition. Keep in mind, we're talking about a petition, the petition itself. So they write to cancel the petition after it's been approved. They can then withdraw the approval, which means it takes away your ability to get the green card. So if they did say if you already got the green card, it's too late for the petitioner to withdraw it. But if at any point before you get the green card, they decide that they want to withdraw the petition that they filed, then that's big problems. And an approval is not going to save you from having it withdrawn. Now, here's where I say this though. If they're doing this, if for example, a US citizen spouse is doing this, to be able to hold it over your head, they're vindictive. There are options to apply on your own. We work with those options. It's called VAWA. So this is where you definitely don't have to sit down, bite your nails, and say it's all in the other person's control. You can determine whether VAWA could be an option for you, just depending on how they're treating you and whether they're using it as a vindictive tactic against you. Now, even if your I-130, and this has always been the case, even if your I-130 was approved, your petition was approved. We're not talking about the I-45, we're talking about the I-130 petition was approved. Then they're saying that they can still remove you. And that has always been the case. I-130 alone does not give you protection. However, adjustment of status or a visa, we have certain options we apply for our clients. Those can offer protection. So make sure you know the difference and make sure you have legal counsel advise you along the way about the risk. So those are some of the changes that are happening. So make sure that you understand this. No family-based or marriage-based case is simple. One mistake can mean a denial without any chances. And as soon as they deny, we are now seeing that they're sending notices to appear. We're seeing that now. This is basically a part of life. So just know, no, it is the stakes are high. Don't assume because this is family-based, marriage-based, that it's going to be easy. They have changed it to be a lot harder, more stringent, and you have to make sure that you're ready because you may not get any more chances to submit this. If you, for example, you have a strong case, you qualify, but you submit a sloppy case thinking, I can give them information later on, then you get a denial. And you're like, okay, I got the denial, but I can quickly refile. But before you refile, you get a notice to appear in immigration court. Now that you have a notice to appear in immigration court, you now are in deportation, and it's going to be a lot harder to get approved. So that's just an example how quickly a simple case can turn into an ugly and complex case. So make sure that you're doing it right. There's really very, very little room for errors. That's how they're designing this. They're designing it so that they can do denials very quickly and that they don't have to give any chances. They don't have to give you notification that maybe you made a mistake that can be corrected. They can just deny. So keep that in mind, guys. going forward. And give us a call. That's why we're here. We are here to make a difference, to help get you through the process smoothly and successfully. We've helped many immigrants do this, and we're very experienced here at ST Law Office. So schedule with one of our attorneys. Give us a call. I put my number big and bold at the top on the screen on TikTok. So go ahead and call the number, and you can go to the videos on each platform. You'll see my number on all of them. Give us a call. We have multiple attorneys here to help. And believe it or not, our schedules are filling up very quickly because it's a busy time and people need help. All right, so now I'm going to answer questions quickly. So I'm going to start on TikTok, work my way through to YouTube and Facebook, and Twitch, and then I'm going to go to Instagram. So put your questions in the comments because I'm going to scroll through and answer questions. I had my green card interview through marriage. It got approved. No update on web page. Should I be concerned? Not necessarily. Sometimes you just get the letter in the mail without them updating it. Can you talk about bona fide determination notice on you? So if you get a bona fide determination on you, you'll then get a work permit. That's about 4 years. And then you'll continue to be able to renew this for the before the expiration until you get your U visa, until you they make a final decision. I'll call you tomorrow. Definitely give us a call. Make sure you save it in your phone and give us a call as soon as possible. Keep in mind, we're 24/7. If you're up at 3 in the morning and you're like, I need to get this done, give us a call. We have our teams are working 24/7. I just applied for my citizenship, but my green card expires next month. Would I get denied? No, you wouldn't. You should not. I've had clients have expired green cards. However, what I would say though is for your own protection, you should apply for your renewed green card. The reason I say that is because you are required to walk away with current proof or walk around with current proof of your green card status, especially now. Because if you're stopped and you present them an expired card, it puts you at risk for detention. Unfortunately, right now we have ICE agents that are just taking people off the street because they have a quota to meet. And so they're just grabbing anybody that cannot show status. So what you should do is still apply for your renewal and or get an I-551 stamp in, and usually the I-551 stamp, you have to show that you are in the process of applying for a renewed green card. Now they will issue an extension to you for a few years until they can issue the replacement, but hopefully you'll get your citizenship. But in the meantime, you'll have proof. I sent to NVC, I paid the fees. Is there any way for denial my documents all correct? Yes, if the NVC is very picky, if the documents are not formatted properly, believe it or not, you won't get a denial of your entire case, but you'll get a rejection. And then you'll have a chance to fix it, and then they'll tell you whether it fixed it and then move your case forward from there. But your case can be stuck for a very long time if you don't get it right. I usually say one mistake at the NVC stage is a 6-month delay. Why? It's going to take them 3 months to review and find the error or whatever you need to do. They're going to notify you at about 3 months, and then when you submit it, it might take you, depending on what they're asking for, might take you a minute, might take you 2 weeks, might take you a month to do. Once you resubmit it, it's going to take them another 3 months. So it could be 6 to 7 months delay just by making one mistake at the NVC. So it's also very important to get help. We also help clients at the embassy. Interview was approved, but no green card. No green card was sent after 2 years, but USCIS scheduled another interview. That is definitely concerning, and it's going to be complex. So you need to talk to an attorney. If that's the case, if you were you given a 2 year green card, we need to know more. I don't want to jump to conclusions. So I've been married 8 years to my hubby. Can we get him legal here in the US? There may be possibilities, but we have to understand what the situation is to be able to determine how to help. But there are options, but we have to figure out. So we need to talk to your husband, schedule an appointment. The number's right there on the screen. You can also go to the link in the profile, LinkedIn profile on TikTok, LinkedIn profile on Instagram, or you can go to the description of the video and you can get the link and go to the link. You'll be able to schedule your own appointments there as well and access our website. Do they open all deportation case with I-130 approved? Keep in mind, I-130 approved does not give you protection. Are they opening all deportation cases? Yes. Cases that were administratively terminated, they are. So you want to make sure that you respond and you defend it because they are submitting motions to reopen terminated cases. No 2 year green card was issued. I only had 5 year work authorization. So yeah, if it was not issued, you need to talk. You definitely need to talk to somebody. I got 2 counts of child endangerment dismissed. Will this affect to be a citizen? No, if it was dismissed, then there is a chance, no. But how was it dismissed? Did you have to plead guilty? It sometimes it depends on how it was dismissed. If it was dismissed in a certain way, it might be seen as guilty by immigration still. So you need legal advice when it comes to offenses, guys. Definitely make sure you have an attorney because it can get sticky, and really it's on a case by case basis. Very specific research has to be done to determine what the effects will be. What happened with the discretion fiscal? My case was pending with ICE. I'm not sure what that means. Is it advisable to cancel my 4 year pending VAWA and marry my current partner who is on a J1 visa? So give us a call. But what I would say here is why would VAWA gets you the green card? Marrying a J1 is not going to get you status, especially if you're already out of status, which if you've been waiting for VAWA, you likely don't have status. And so marrying a J1 visa holder is not going to put you in a better position. I highly suggest you definitely get legal counsel or talk to your lawyer for sure. Um, how long does USCIS take time to make decision after I-130, I-485 interview? It could be months. I've even seen years, just depending on what they're looking at. I got DUI reduced to public intoxication. I plead no contest. So once again, that's when it comes to offenses, you need to talk to us individually. We need to look at everything, the statute regarding public intoxication in your state and how that can translate to immigration law and then how that could affect you. I'm supposed to go to master hearing so my deportation can be dismissed. So make sure you're talking to your attorney because who is doing the dismissal? If it's ICE that submitted for dismissal, you need to be very careful. But if you submitted for dismissal, then that may be something else. So yeah, make sure you talk to your lawyer for sure to understand what that means. Um, What's the birthright citizenship status? So we have injunctions in place that have stopped any kind of termination of birthright citizenship right now. Um, I just applied for my citizenship, but my green card expires next month. Would I get denied? So go get your renewal and get an extension letter. Not Not everyone is as persistent as you. I really admire you. Thank you for that. I really appreciate that. That gives me fuel. I had my green card interview through marriage. It got approved, but it's been days and still no update. Yeah, so you may just get the letter in the mail. Sometimes they don't update, especially if they're very busy. I got an extension for 48 months and we have an 8-year-old daughter. So should we have an interview? Um, they may, it depends on the strength of your application and it just depends on a lot of different factors. They may waive it if you do submit a strong application. Where do you live? So I'm taking it, where does my law firm live? We are in Delray Beach, Florida, and we also have an office in Boca Raton. That's our base. We represent clients in all 50 states and the globe. I had my green card interview. Okay, so I answered that. Do you handle clients in Georgia? Yes, absolutely. We represent clients in all 50 states and the globe. We help everybody no matter where you're from. Give us a call. We are a safe space to talk about what you're going through to determine whether there are options. Now, I know I talked to you about some major changes that are happening with the when it comes to family petitions. But guys, it still does not mean that they're not giving out any green cards. What it does mean is that you know the stakes are higher. You just need to look whether if you don't qualify under family, I'm not saying don't qualify for your family base, but you will now have to take steps to be very careful just because they can take actions that can negatively affect your application, triggered by triggered by certain types of red flags. If you do qualify for family or marriage base, give us a call. We can help. Don't go it alone because it's very complicated right now. There are also other options that you need to, if you're listening right now and you don't have your papers here, you maybe came into the country without papers, or you're here because you overstayed your visa. Just know that we also evaluate whether there are other options that can help you to get protection here. Thank you so much for the gifts. I appreciate that. I'm 740 days waiting. It's not too much time for waiting. So I'm not sure what I'd have to look back to see. Actually, yeah, so no, it's not. It is not, absolutely not. Not for the removal of conditions. It's taking up to 4 years to get your 10-year green card from a 2-year. Got a request for additional evidence on I-130 same day after interview on I-45. Is it good? Request for evidence means that if they ask for the information, that's all they ask for, then it's likely if you can provide that information, it will result in a positive outcome. Okay. I have MCH on August 8th and I'm requesting for voluntary departure. Okay. So voluntary departure often allows you to leave. And if you leave, it's not seen as a deportation, which means you do have the ability to possibly return through an immigration process. Can I call later? You can call right now. You can call later. We are here every day, 24 hours. What about I-601 waiver? And this is where it's important. If you have any issues in your background, an I-601 waiver can help to forgive those, like criminal offenses, any kind of misrepresentation or fraud in some cases may be forgiven with an I-601 waiver. With T visa work permit, do you have to wait the whole time to get adjustment of status for 4 years? So no, 3 years is when you can officially apply, and there is an early adjustment process where you can apply early for the green card. I had my green card interview through marriage. It got approved, so I answered that. Do you do visa applications? We do certain visa type applications, but it just depends on whether you qualify. So we ask questions during our appointment to see if you qualify for those options. How long does the embassy appointment taking and I-601, I-212 filing for spouse in Honduras? So I-601 and I-212, you could, count on it being about 2 years processing time. And the interview is usually it takes about 2 years. So the waiver, considering the waiver does cause a delay in the timeline. So it could be 3 to 4 years, just depending on, the order of the waivers. Can you talk on, let's see, I had my green card, so after that. How can I get in with immigration? My husband from Nigeria told me he doesn't like. So I'm not sure what that means. Did interview 1 year, no, and still no decision on my case. It's being delayed. What can be done? It depends on the reason why. It could be a number of reasons, so it's hard to say. I just applied for my citizenship, but your green card is about to expire. Still go ahead and apply for renewal, just so that you're not walking around with an expired green card that can put you more at risk. All right. Now I'm on YouTube and Facebook. I'm not sure. Does TB affect your I-45? It could. In the medical, it could. Um, if it's not cleared, you'd have to do treatment. Uh, Hello there. All right, I'm on Instagram because I don't see many questions on Facebook or YouTube. So, hi there, friends on Instagram. I'm going to go through your questions and then I have to call it a night. If you get divorced after getting a conditional green card and your marriage haven't reached the 2 year mark, can I still get a waiver of documents? Yes, absolutely. It's essential you do that waiver now, and you can actually apply before the 2 year card expires. That's what we help with. There is no one document. It really comes down to advocacy here and also providing applicable documents that you have that can show, either show the divorce, the final divorce, and show that your marriage was real even though it didn't work out, it was real. And if you're applying without the spouse to go from the 2 year to the 10 year, based on mistreatment, that's also required to have your statement. So definitely give us a call. We do those. We've gotten approvals based on those. So give us a call. Good evening. Good evening. Is it true that there will be no more T visa? Not true. We actually have gotten approvals. Actually, one of our clients, they came up within the last week. She got approved for a T visa, and her children just got their T visa from the embassy and joined her here in the US. So I can tell you without a doubt, there is T visas happening now. Now, will there be no more T visa in the future? No, keep in mind that changes are happening, but it has to be done through Congress. They would have to vote on it. They would have to get rid of that whole law. the trafficking victims TV, let me see, trafficking victims, basically the law that dictates the T visa and protects victims of trafficking, that has been here since the year 2000. So they would have to delete all of that, and that would undo all the labor in regards and all the laws that have protected victims of trafficking. So will that happen? It's unlikely that it's going to be a situation where they're just going to wipe out the T visa, and they cannot do it without going through Congress first. N400 processing time, you're looking at about 6 months. We have taken action on your case, but for more than 2 weeks, there's no update. What can I do? Sometimes an action on your case could be they updated something quickly, doesn't mean that they made a decision. How do I transfer from OPT to marriage green card? So you wouldn't transfer, you would just file your a marriage green card application documentation, and that should help you to make that transition. Do you handle H4 EADs? It depends on what type. You can always give us a call, and we can find out what your situation is to move forward with that. Does new discovery in a case still jeopardize getting green card if the case is dismissed? Yes. Yes. So if they find new information, absolutely, it can jeopardize your ability to get the card. If I am married 5 years and living here for 2 years, my husband and I am not living together anymore, can I still file for citizenship in 3 years? We also have a son. No, you would not be able to do it in 3 years. It would have to be 5 years if you're separated from your spouse. If I'm OPT and eventually get married to a US citizen, do I need to stop my OPT work before or after filing? No, you don't need to stop it. Your OPT work, you'll actually get a new work permit that will help you to continue to work while you wait for the green card through your US citizen spouse. Lost green card. What should I do? You have to apply for a replacement using the I-90. It can also be approved. So I'm seeing somebody answer questions. I am a permanent green card holder as for my kids, but it keep updates that what should I do? I'm not sure what this is saying. I'm a permanent resident. I'm a permanent green card holder. As for my kids, okay, so I think your kids are also applying and it keeps updating. I unfortunately I'm not sure how to follow up on that situation. Is it normal for an I-130 to take more than a month? I applied marriage based. We live together. We even have a child together, but my case is taking long. Yes, it takes way more than a month. You could be looking at maybe 10 months to a year and a half uh, for that process. So hang on and just, hope for the best. Are they arresting people at their interviews now? This is not widespread practice, but if they do find anything in the background, like a criminal offense, or that they're rendered deportable, they are, choosing to target certain people, especially if there's fraud involved, or there's a criminal conduct involved. They're detaining those people at their interviews. So that is a possibility. Good night. My son turned 18. At what age can he file for me? 21. when he turns 21. Good night, ma'am. Hi, good night. Can a congressman ask for review? Yes, a congressman can ask for review, and sometimes they do. They don't guarantee results, but in some cases, they can make a difference. I'm doing an adjustment of status through marriage. We're living in NY, New York, but I work in Tennessee. Will that affect the process when interviewing? Yes. Yeah, because they definitely hone into not living together. The fact you're not living together, they immediately think fraud. So this is where it's important to, make sure that you have a solid explanation as to why you are in Tennessee, your spouse is in New York. I do understand, things happen, your spouse has to work somewhere else other than you, and that may just be the reality now. So, but you need to make sure that you can explain that to the officer. I've not been in the US. I live outside the US. What abuse? So I'm not sure. I'm not sure. So w- since I don't, it sounds like there's a lot going on. Richie Rich, give us a call and let's talk to you individually. I've been married for 5 years and living in the US for 2 years, but my husband and I don't live together anymore. Can I still file for my citizenship in 3 years? No. You have to wait the 5 years if you're separated. If you have evidence that the abuse has happened in the US, so please keep in mind that nobody should be giving advice here. I don't want this to be a platform where we have village lawyers that, tell people to do things and then it's wrong. We don't have any room for errors, guys. So don't take anybody's advice here. Make sure you're seeking legal counsel. Don't take people's advice in the comments. Make sure you're seeking your own personal legal advice. What do I have to do to get my I-130 form approved? But I don't live in the States, but I'm married to a US citizen. It really is a waiting game. It takes about 9 months to a year and a half to get that approval. Um, sorry, so I'm not sure what that's saying. Does T visa have interviews or interview during green card? There's a possibility. If they determine that they need to talk to you about certain facts or issues that they're spotting, yes, you may get an interview. Can you handle an N600 case while still processing? It's possible, but we have to talk to you about your situation to figure out what the issue is and whether we can help. Oh, thank you so much. Oh, thank you. Thank you for this. I appreciate it. Thank you. Can I update more evidence after my green card interview? The interview was good and fast. Yes, if it's a petition and you file the petition online, there is a possibility to upload. But here, from a strategic point of view, keep in mind that um, from a strategic point of view, is it a good idea to be submitting additional information, especially when you've already been approved, or you think you're going to be approved, or the interview went well? Is it a good idea? This is where it is so important to make sure that you get legal advice and at your attorney. This is definitely a moment to consult with your attorney because you don't want to be throwing too much at them. You don't want to be if everything is good, why keep going? Maybe just wait to see what else they need if they have to make a decision. So I'm not telling you don't do it or do it. I'm saying though that really is a strategic question. Can I upload more to answer that? Is VAWA interviews still going on? Yes, they're going on for certain individuals. So they, are reviewing applications, and if they have questions, they are reviewing. Yes. I received my EAD today and lost it. Please, will replacement come with same validity and processing time, same like initial? So unfortunately, getting a replacement is you're looking at about 6 months or more. Unfortunately, it's very frustrating. I'm so sorry that happened. Can you bring your baby to the interview as evidence? That's a strategic question. You don't necessarily have to bring your baby as evidence. You have the birth certificate of your child, you can bring that. Here's bringing your baby, to the interview. The officer could possibly witness the family dynamic between the both of you. Maybe see how the baby resembles the both of you or your spouse. The downside is the baby can be distracting, and for example, if the baby's crying, if your baby is irritable, it can then cause the officer to become frustrated. And so you have to take that risk in mind, is that you may not be able to focus so much on the questions or the interview because you have your baby there. But here's an alternative: is you carry your baby's birth certificate to the interview, carry a copy and then the original, and then give the officer the copy of the certificate showing both of your names on the birth certificate. That can be more evidence than even just having your baby there. They're going to want to see document evidence, because you could, technically, you could take anybody's baby into an interview, by the way. So they're still going to want to see a birth certificate to make sure that that's your baby with your spouse. I did an interview. I did an interview 2 weeks ago. The interview was quick. The officer didn't ask me for more evidence. When can I expect an answer from USCIS? So it could be you said 2 weeks already, but my experience is it could be a day later, it could be 4 months later. And I've seen it go as long as a year and a half for some people. So it just depends on what they need, or if they're looking at anything further. Hi, I-130 approved, working on I-601A waiver. Also, I have the chance to file for a U visa. Would be a smart option at this time. Pursue all options. It's going to be smart to make sure you're pursuing all your options. Filing the U visa means that you could get protection here while you're waiting for the I-601A waiver to go through. The I-601A waiver in itself does not give you protection from deportation. So having a U visa, qualifying for a U visa, could give you the protection to stay here while you're going through the I-130 process. Are they taking longer to issue T visa receipts? Yes. Than normal? Yes, it's normal. They're taking about 4 months now. Why immigration arrests people to the court during the interview? I do not agree with it. It does violate the very principles of justice. The fact that people are doing the right thing to show up to their hearings and go through a process. But they do see these immigrants that are complying, unfortunately, as easy targets because they're there and they have a quota to meet. So they're just grabbing people. There has been a class action lawsuit against this, so I'm sure we'll have an update on this, and the practice of it is just, you know it goes against even encouraging compliance, when people now realize that if they go to the court, they're going to be they may be arrested. I filled my I-130 form online for my wife. It's been 10 months now, no update. Is it normal? Yes. Married to US citizen for 14 years, how long the process would take? So if you're married to the US citizen for 14 years, how come you haven't gotten your papers yet? It something sounds like a red flag here. So if your spouse is not giving you the green card, no, we want to talk to you to figure out what maybe there are other options there could be for you. Now USA says that divorce is not valid. We both are in the United States at the same time and sent notarized and apostille powers of attorney to Colombia so the divorce could be processed there. Now, USA says the divorce is not valid. However, my ex-wife already became a US citizen based on the same divorce. Can you take my case now? So definitely give us a call and we can talk to you. We received an RFE. We believe we're Colombian citizens who got divorced in Colombia through powers of attorney. So if it's legal in the country that you're from, it's valid here. So sometimes the officer makes mistakes. And so we would have to check that. So give us a call and then we would be able to discuss with you what your options are. Can I apply for my son? He's 24 years old. You can, if you're a US citizen, and your son, you can, but keep in mind that it could be anywhere from 5 to 7 years if they're 21 or older. If they're married, it's 12 years. And if they're under 21, then it could be much shorter. I would carry the baby. Well, you have to just think about the pros and cons. But carrying the baby, once again, keep in mind, guys, carrying the baby alone may not be enough. You have to show proof that that baby is yours and the spouse's by carrying the birth certificates with the of the baby with both of your names on it. Can my husband claim me for a marriage green card if he was in prison for a minor charge? Yes, that's a possibility. Now, keep in mind if they do call you in for an interview, there could be they may make accommodations. They may allow phone interview for the spouse, but all of that has to be arranged. I'll better explain the new discovery was that the person lied and have new now come forward with the truth. Does this still affect me to apply for the green card? Um, well, lied about what? It was a criminal case. So give us a call because we need to know who if was it your US citizen spouse that committed a crime, they lied. Having a criminal history as a US citizen petitioning for their spouse is not going to necessarily stop them from petitioning unless it's a crime under the Adam Walsh Act where it involves a child. So, it really depends on whether their arrest will affect your case. All right, guys, that's gonna be it for me tonight. Thank you so much for your time. I appreciate it. Remember to like, subscribe, hit the notification bell, follow. This is how people get notification that there's this information that can empower them through their immigration journey. But keep in mind too that by doing that, when I come on, because I come on different times of the days, when I come on, you get notification I'm live, and then you can hop on with me, and then you can ask your questions. I'm going to aim to come back tomorrow again. So please make sure that you take those actions so you can see when I'm on, so you can hop on if you're available to ask those questions. Have a great, great night, everybody. And remember, we're open 24/7. So you're thinking about us, you need to figure out options here. You're here without your papers. You came in without papers. You're about to enter a marriage. You're about to you're thinking about doing family-based or marriage-based application, or you don't know what you qualify for, give us a call. That's exactly what we help with. All right. Have a very good night, everybody. Thanks for joining me, and I hope you can join me tomorrow. Bye bye.